Bobby is the Charles I. Francis Professor in Law at the great University of Texas School of Law. Bobby's a national security law specialist. He's recently served in the Justice Department in connection with the Detained Policy Task Force. He's a member of the Advisory Committee of the American Bar Association's Standing Committee on National Security Law, a senior editor on the Journal of National Security Law and Policy, an associate member of the Intelligence Science Board, a fellow of the Brookings Institute, a term member of the Council on Foreign Relations, and a member of the American Law Institute. In other words, he's your go-to guy on national security law. A resume, in fact, that reads like someone 3, if not 4 times his age. It's my great pleasure to introduce my friend and colleague, Bobby Chesney, to speak about military detention.
Thanks, Derek. It's a pleasure to be here. I'm going to grab my water off the table. I've arranged some Lionel Richie for you guys to listen to. Just in case I'm not entertaining you, it's because of music. It's a real honor and a privilege to get to speak to this audience. It's also pretty fun just to be in Newport in June. Austin this year is rather hot and humid, horrifically so. In fact, I was going to open with sort of a joke about the contrasting weather, and it occurred to me, I do actually want Derek to come back to Austin when his time as the Stockton chair is up. So instead, I'll just say it's amazing how similar the weather here is to Austin. It's almost unchanged, Derek. Come on back, we need you. Speaking of UT, I want to begin my remarks by framing the topic, referencing a paper I read recently by someone we just heard from, and I think he's gone now. Mike Schmidt, are you still here? Well, okay, so I was looking at something Mike had put up and circulated on the internet, and it was from a piece he wrote in the Harvard International Review, where Mike dwells on the manner in which changes in the strategic environment inevitably have an impact on military practice as well as on the law of war itself. And as an example of the circumstances that can create such evolutionary pressures, he points to the increasing prominence of asymmetric warfare and insurgency, especially the tendency of insurgents and terrorists to endanger civilians, both by attacking them directly and by failing to distinguish themselves. The paper goes on to talk about the consequences of all this in the context of targeting, and he dwells in particular on rules of engagement. It's a very well-written, interesting paper in that respect. He observes both that the U.S. as a policy matter has adopted restraints in an effort to conform to this distinct strategic environment, and that critics who want the U.S. to go further often pitch their arguments not just in policy terms, but in decidedly legal terms. This precipitates debate about just what the law is and what it might be becoming in the counterinsurgency and counterterrorism context. Those same evolutionary pressures and those same debates are expressed, of course, also in the context of law and policy of detention operations, which is the point of my conversation with you today. Let me first frame that issue a little bit more by referencing Iraq, which won't be the main focus of my comments, but I think it helps to start with it. Our detention policy in Iraq, the framework, the legal framework, has evolved dramatically over the past 7 years. We began in 2003 with the traditional international armed conflict-rooted system where detention without criminal charge found direct authorization and clear authorization in the 3rd and 4th Geneva Conventions. But this was followed by a long period from mid-2004 till the end of 2008, something we can call the mandate phase, where, as we'll see, I might talk about a little bit more later on, the UN Security Council mandate was the source of detention authority in this security internment context. And then finally, from 2009 until the present day, we operate under the security agreement between the United States and Iraq, where the main focus is, indeed the theoretically exclusive focus should be, reliance on the Iraqi criminal justice system, acting with and through the Iraqis. That's a lot of policy change, a lot of innovation, a lot of legal change in response to the changing strategic environment in Iraq over time. Not to mention a large-scale, massive amount of detention without criminal charge. Interestingly, however, despite all that, the principle of detention without criminal charge in Iraq has never been accompanied by the same kind or scale of legal debate about the foundation and scope and nature or very existence of that detention authority, at least in comparison to the seemingly endless debate we have in relation to the far smaller scale detention operations in Guantánamo. Why might this be? There are many reasons for this disparity. First, as to Iraq, as I mentioned a moment ago, we did indeed get from the Security Council repeatedly affirmative positive law authorizations for the security internment regime that we were relying on through the bulk of this period. This effectively eliminated debates about whether and how the law of war otherwise might have justified or might not have justified or permitted the practices we were using. Of course, we don't have quite the same clear positive law authorization in other detention contexts elsewhere. Another major difference has to do with litigation. There's been almost, not entirely, but almost no detainee-related litigation in the United States emerging out of Iraq, with a few small exceptions. And relatedly, there's been curiously little interest in narratives about possible false positives or an innocent detainee narrative, the sort of thing that we very much associate with Guantánamo. And that's notwithstanding tremendous public interest in conditions of confinement and interrogation practices, as we all know. So notwithstanding that conditions of confinement interest, just really not much focus on detention operations in Iraq otherwise. The contrast with Guantánamo is quite sharp. In Guantánamo, the spotlight of litigation shines very brightly, as does, and not coincidentally, as does global media interest. This produces or helps to air out a focus on the possibility of false positives or innocent detainee narrative in relation to Guantánamo. It creates an abiding interest in the legality of the detention system itself and the merits of particular detention decisions. But litigation does more than that. Litigation ensures that the debate will be framed, of course, in legal terms rather than just in policy terms. And it also ensures that that legal debate will be joined in relatively crisp fashion between the competing sides, and that at least in some instances we'll actually get a resolution, that it won't just be a debate that takes place in the pages of the newspapers, but rather some decision maker will weigh the competing arguments and begin to take positions on just what the contested law actually is, or what it's becoming. And that brings us to the actual subject of my talk, and that is the way that the Guantánamo litigation has become a forum for developing the law relating to military detention without criminal charge, and how this takes place in the context of the very same evolutionary pressures associated with asymmetric conflict and counterinsurgency that Mike Schmidt wrote about in the paper I referenced a moment ago. What I specifically want to do is walk us through what the litigants and the judges have been saying about just who it is that in theory can be detained. Not the evidence against particular detainees in particular cases, but the more abstract substantive law question of where the bounds of detention authority actually are. And along the way, I want to draw attention to the question of what sources of law are actually informing that judgment, or purportedly informing that judgment. So, it's hard to know where to start. This is somewhat arbitrary, but let's start with a general overview of what's been happening over the past 2 years. Since almost exactly 2 years ago, the Supreme Court in Boumediene v. Bush decided that detainees have a constitutional right to seek habeas corpus review of their detentions. The habeas corpus process has not been quick, it is not over, but it has been moving along and some things have been happening. Let me give you a quick rundown of some data, or some scorecard issues, if you will. That's how the media loves to report this. Now, according to the public record, at least, in terms of things that have been unsealed or classified, we've got decisions on the merits from the district judges as to 33 individual Guantánamo detainees. Now, if you've been following the news accounts, you may notice that number and say, wait a minute, I read that the total score is 50, and they make the breakdown of wins and losses from 50. Why does that say 33? It's because there's a technicality here in relation to the 17 Chinese Uyghur detainees who are probably familiar to most of us. It's been much in the news. The Uyghur detainees were held as enemy combatants on the theory that they were members of the East Turkestan Islamic movement, ETIM, and that ETIM in turn was part of or associated with Al-Qaeda and the Taliban, thus bringing these guys, if they really were members, within the scope of detention authority. As it happens, the 17 Uyghur detainees challenged this claim, in particular the claim that ETIM was sufficiently associated with Al-Qaeda and the Taliban for detention, and they prevailed. But it wasn't in a habeas case. Technically, it was the one merits decision under the pre-existing judicial review system that the court struck down as insufficient in Boumediene itself. So this, this was under the Detainee Treatment Act of 2005. It was a decision rendered shortly after Boumediene itself. The important point, of course, is that the government lost those 17 detainees won, which is why you typically see their number added to the habeas decisions as well. There was subsequent, just to be clear, there was subsequent habeas litigation on behalf of those Uyghurs. It's been about whether a district judge has the authority to order their release into the United States in the event that no other third country home can be found for them. And that is, in the end, not going in their favor. But the cases still count as defeats for the government in the larger sense of merits. So, back to the 33 cases. What about the 33 habeas cases? 19 wins for the detainees. 19 wins for the detainees. Of those, the government, without appealing, went ahead and did transfer or release 11 of those 19. The government is appealing 5 of the remaining 8 and has still time on the clock, as far as I know, still time on the clock to decide for the remaining 3. You do sometimes hear in the media discussion of people winning their cases and nothing happening, suggesting that the executive branch is essentially flouting judicial authority. That's not a fair description of any of the habeas cases. The place where that has some bite is in relation to the Uyghur detainees, of course, who famously are very hard to find homes for. 12 of the 17, as I understand it, have already been released. That leaves 5 remaining Uyghur detainees. And there's a debate about whether, have they had opportunities that they turned down? What's the situation with them? But that's what that debate is all about. Now, on the whole, that's either 19 or 36 individual defeats for the government on the merits. As to 14 wins on the merits in the habeas cases, and there's a mix of situations happening there. 2 of these have already been affirmed on appeal. Note that those are the first 2 publicly disclosed D.C. Circuit rulings on the merits of any of these issues, both going in the government's favor. And I'll talk about both those cases, Al-Bahani and Awad, later on. There will be more, I'm quite sure. Now, 11 appeals are pending. And I guess that's how we know there will be more. And those will be obviously very interesting situations. It may be that there's one that was mooted. I'm not real sure about what the situation there was, but that's the lay of the land. Now, how much more is to come? Is this pretty much the end of the process, or is this just the beginning? I really don't know for sure, because I just don't know. I haven't been able to determine precisely how many individuals have currently pending active habeas cases. It's hard to know, in part because people do get transferred. As we know, these transfers are taking place all the time, and it's just hard to dive into PACER to pull these things out of the docket. What we do know is the following: that there are less than 200 total detainees at Guantánamo. My sense, and the sense of others who follow this stuff closely, is that if no one else were transferred from this day forward, which is not necessarily a very realistic assumption, we're probably not yet at the halfway point of the cases that will go to the merits in the habeas process. So this may be the leading edge. My sense is maybe about 1/3 of the way through, maybe 1/4 of the way through, barring what transfers may be. It's also complicated by the fact that an undetermined number of cases that were brought on behalf of detainees ultimately got dismissed because the attorneys involved could not get the detainees to affirmatively authorize the representations, which raises another scorecard issue. How do you count those? Do they count? Is that equivalent to a detainee admitting that the allegations are true? I don't think we can assume that. There's any number of other reasons that could explain it. That's one possibility. They're a hard one to categorize. So there's some pros and cons to this scorecard approach to figuring out what's going on here. The scorecard may change a bunch and upset the currently dominant narrative, which is the government tends to lose these things. I expect, my own estimate going forward is the government's going to start winning more than it's losing as they start progressing into cases where the government's evidence may be stronger, but you never know. One thing's for sure is that the scorecard wins will dominate the media coverage, alongside analysis of the evidentiary strength of the case in particular instances. What you will not see is much close examination of the law that's actually an issue or being discussed and developed. Some would say created, some would say interpreted. Either way, what the legal decisions are in the more abstract sense. And yet the courts have had a lot of interesting things to say on this point, and it's well worth our paying attention to what they have to say. Unfortunately, on the particular question that I'm going to dwell on here, much of what they've had to say has not been entirely consistent. So let's take a closer look, and we'll start with the last administration's proffered standard for how you define the substantive scope of who may be detained. And I'll take this from the Combatant Status Review Tribunal standard, the CSERT standard, which is quite familiar to many of you. The Bush administration, from about mid-2004 until the end of its time in office, essentially hung its hat on the following definition that is a representation of its this view of who could lawfully be detained if you could prove someone sufficiently, there's enough evidence to show that they're in this category. There are two tracks here. One is associational status based or membership based. Those who are part of is the word being used. I'll sort of use that interchangeably with membership, although part of may be a more refined way to think about it. And then there's a conduct-based prong, those who provide support to. So you're either a member, or you're not a member, or you're not part of the group, but you're providing support. So you're engaged in certain conduct aiding that group. To who? To Al-Qaeda, Taliban, or associated forces engaged in hostilities against the United States or its coalition partners. Now, was this standard actually lawful? Does this accurately stay within the bounds or whatever the legal parameters are? That's a really tricky question conceptually once you start to think about it. What exactly is it we're asking when we ask, is the CSERT standard, or was the CSERT standard lawful? Or is any future standard that we're about to go look at, are any of them consistent with legal bounds? Why is it tricky? First of all, there is raging debate about what bodies of law are relevant at all to answering that question. Is it a question that's purely a matter of domestic law? For example, is it simply a question of whether the CSERT standard is consistent within the scope of the September 18, 2001 authorization for use of military force, or the AUMF, as I'll simply refer to it, whereby Congress famously authorizes the President to use, quote, all necessary and appropriate force against those he determines planned or perpetrating the not only attacks, those who harbor them, to prevent further attacks. Or continuing with a purely domestic focus, is it instead to be measured in reference to the President's Article II authorities on a self-defense theory, on the prize cases, or something else? Or is it instead a question of international law, at least in part, if not in whole? For example, is it a question defined or answered by the law of armed conflict? Is the law of armed conflict a relevant source independently? Is it relevant to fleshing out what the AUMF means? Is it relevant to fleshing out what the President's Article II authorities are? For that matter, what about international human rights law? What relevance, if any, does the ICCPR have? What about customary international human rights law? A host of questions about what bodies of law we should even be considering. And then you come to a second set of complications, and that is the debate that rages within each of those domains as to what the actual content of those bodies of law are when applied to this particular circumstance. A million questions lurk here. To stay with the IHRL theme for a second, with human rights law, there are questions of lex specialis and its impact. There's questions of extraterritoriality of American treaty obligations. And insofar as it's presented in the litigation context, there are pressing questions of non-self-execution, and so on and so forth. With LOAC, I mean, we could spend the entire conference fleshing out these debates. Does LOAC have anything to say about detention authority affirmatively outside the international armed conflict context? If it did, does it say anything useful about what it means to be part of a non-state armed group? What counts as being part of? Is part of a reasonable test in this context? What about support? Is support at all theoretically a permissible trigger? And if so, what is the measure of support? One thing that jumps out at you when you read the habeas cases and start looking at how the cases are actually being decided, you realize words like part of and support don't tell you much. The cases are about fact patterns in which people train. They stayed at guest houses, or they traveled to tour war, or they were arrested in certain circumstances, or they were in the company of certain people. That's what these things turn on. In broad terms like part of and support, they're useful catch-alls for these umbrella concepts, but they obscure what the real moving factors are. So you have all this complexity. And it's made worse because, of course, as the Schmidt article I referenced highlights for us, we are in this context in which changing strategic circumstances are exerting pressure on existing legal frameworks that, either for good or ill, are pressures to perhaps evolve to adapt to these circumstances. So no wonder it's such a tangled debate. All of this was, of course, true before the Supreme Court decided Numedia in 2008. And in fact, in the litigation and the briefing leading up to that decision, these issues were directly in play. Everyone focuses on the fact that the Supreme Court decided that case as a case about access to the courts. Obviously, the main focus is what the opinion was about. It wasn't the only issue briefed to the court. the court received a briefing on, and the question was presented on what's the substantive detention standard, which is sort of remarkable because that's a huge question. And when you look back at the briefs, some very interesting things were said by the litigants in the course of that litigation, trying to get the Supreme Court to take a position resolving this question. So let's look at that a little bit. The petitioners themselves, Lakhdar Boumediene and his colleagues, these were people captured or arrested in Bosnia on suspicion of plotting to attack a U.S. consulate. The Bosnians started a criminal process, but dismissed the charges for want of evidence and turned them over to U.S. authorities. They ended up in Guantánamo. They argued that first, the law of armed conflict must inform any analysis of what the scope of the government's detention authority over that might be. And second, that there's, in this particular context, no such thing as combatant. So it's not a discussion of combatant detention authority. This is the line of argument that in this particular conflict, if it's a conflict, everyone's a civilian and we need to deal with it from that starting point. So that was position one. There's no combatants, there must be civilians. But then they said civilians can be detained without criminal charge. We're not denying that. And you might expect at that point to see a reference to the Fourth Convention, some sort of analogy to security internment. I know Ryan Goodman's in the room somewhere here, and he's got a really good article in the American Journal of International Law talking about how these sorts of arguments might be made. They didn't present that argument. What they said instead was that the test for determining who might, or one possible test for determining who could be detained, the court should look to DPH. Use the direct participation standard, which of course is a target standard, as a measure of who may be detained. Now, as we know, we're going to spend the entire afternoon fighting over what Milton's colleagues and others, have said or are going to say about this. Think about what's going on here. People are asking the Supreme Court to use the DPH standard as I would say, the adaptive way of responding to this asymmetric scenario and carving out a detention standard. And of course, if you're going to do that, you're going to need to define it. So the court was being asked to define in a way that would bind American domestic law perspectives on what DPH might mean. It was being asked to take a position on this. Well, what were they telling them to do? They said, well, first of all, of course, there's the thing we all agree on, immediate direct battlefield activities, the sorts of things that we say at the beginning of debates about DPH, as we no doubt will this afternoon, before you move on to the hard stuff. What else did they say? They talked about continuous combat function, in fact. Right? So they said, court, and remember, this is the Boumediene petitioners, these are the detainees. Continuous combat function type ideas can be used in the context of figuring out who's detainable. And they say, we'll go further. Osama bin Laden and other leaders, detainable under this law. Further, conceivably, this is quoting the brief, others who've submitted themselves to the direction and control of the organization. So they actually cast this really broad net under DPH. At which point you might say, well, how did they think this was going to help them? And to that I can say that the assumption had to have been that their view was whatever could be proved against them would characterize them as freelance jihadis, not actual hierarchical members of the command network for Al-Qaeda or otherwise. So in theory, they'd be actually on the outside of this. Which was, you see how this works as a litigation strategy. You give the government everything that they might want except what would reach you, and you sort of throw the others under the bus because that's not your client. It's very interesting, but the important point is not to dwell on the merits of this argument, but rather to make you guys appreciate how close we came in 2008 to the Supreme Court deciding all of this as something that is either going to be framed in constitutional terms or law of war terms, who knows, but the litigation process coughed up this issue, and there was briefing on it, and they ultimately passed on it, but they didn't, by passing on it, bring this to an end. Rather, the explicit decision of the majority in Boumediene was, let's let the lower courts grapple with this first. And that brings us to the habeas litigation, where this story continues. Not this particular line of argument, because for whatever reason, this hasn't been showing up in the briefing in the actual habeas cases going forward. It's moved on to other questions, as we're about to see. The point remains, the courts are going to decide these things because the litigation presents them the opportunity and the occasion to need to do it. So, the first thing that happens is actually in remand in Boumediene itself. Their case comes up before Judge Richard Leon, And Judge Leon effectively says, look, I'm not really going to parse the definition to see whether it matches on, whether it's within any legal bounds. If you were sitting here and heard how I framed my opening remarks, he'd say, yeah, I'm not really interested in that. Just tell me what the administration's definition is. I'm going to use that, and then I'm going to see if there's evidence enough to detain these guys, these 6 guys. He thought no for 5 of them, yes for 1 of them. But he essentially accepted the CSER definition with its membership track and its independent support track as is. And then you get a new administration. So early 2009, the Obama administration comes into office. Many things happen. And as you know, I'm sure the president issued a variety of executive orders, second day of office, one of which initiated a major interagency policy review. I had the privilege of having a very small, minor part in that. The thing about that is that's a long process. And court dockets wait for no man. The press of litigation compelled the administration to begin taking positions on its policy stance as early as March 13th of 2009, which is a famous day because on March 13th, in a case before Judge John Bates, the administration had to come into court and say whether it was going to continue to defend detention without charge, and if so, what the parameters would be. Would it be the same as before? Would it be different? They filed on that date this Hum Lily case, as it's called, the Hum Lily case. And to the surprise of some, but I don't think it should have been surprising, not a lot changed. To be sure, nomenclature changed. So the phrase, with a lot of baggage, unlawful enemy combatant, that phrase was just sort of junked. There was no replacement phrase. Insofar as there's a replacement phrase, the phrase is, persons detainable under the authority of the authorization for use of military force. I'm sure somebody here can come up with an acronym for that. What else changed? There was express language very explicitly embracing the idea that the laws of armed conflict inform and constrain and help define what the president's detention authority is in this context, which was a change in atmospherics, maybe not from the tail end of the Bush administration, certainly from earlier. As to the actual standard, watch closely, see if you figure out what changes. Anybody? Substantial, right? So both tracks are maintained. The component groups are the same component groups, or the objects of the standard. It's still a membership test, or alternatively an independent support test, but not de minimis support because it's clarified that the support needs to be substantial. And I realize it sounds kind of mocking when I say that. I don't really mean to mock it. Some would say that some of the fact patterns or evidentiary cases where at Guantánamo raise a question about how the de minimis exclusion may be mattering quite a bit. Who knows? The standard stays there. Now the question is, what are the judges going to think of this? Judge Bates will have this first occasion because this is his case. What does he say? He does not entirely accept this claim of authority, or at least at first blush it seems so. He accepts the detention authority extends to members of the aforementioned groups. He accepts the membership type test, but he rejects the notion that there can be independent support as a ground for detention, or at least that's the way it looks at first. So he drops that prong of it out altogether. But at the same time, he gives back a little bit by acknowledging that we're not talking here about discrete hierarchical membership organizations. An al-Qaeda fighter doesn't have an Amex card saying members since 1997, like stamps of Sudan and Afghanistan, Waziristan, all over. It doesn't work that way, and he accepts that what may be characterized as support, that actually could be evidence that you are a member in functional terms. There's just not a formality to it. So it's a little bit muddy. Perhaps more important is the part of this ruling where he further specified that the key inquiry is whether the individual, and I'm quoting here, whether the individual functions or participates within or under the command structure of the organization. I realize I should have put that in the slide. Sorry. Whether the individual functions or participates within or under the command structure of the organization. That is, whether he receives and executes orders or directions. Several other judges have essentially followed, cited Hum Lily, Judge Bates said, yeah, that's the right way to think about this. This makes more sense. Not all are exactly squared up with it, though. Let's look at Judge Urbina in Hatim versus Obama. He definitely says he's following Hum Lily and the Judge Bates standard that I just described for you. But interestingly, the fact pattern there involved a person who attended an al-Qaeda camp. He believed he'd become part of al-Qaeda as a result, but the government had failed to prove, according to Judge Urbina, that the person involved had actually actually received any orders and actually carried out any orders in sort of proof of that membership. And that, in Judge Urbina's eyes, meant that he was not in fact detained. Now, it may be that Judge Bates and the other judges who have adopted the humble standard would agree that in that fact pattern, that's what this test means. I can't help but think that's not something they're all necessarily going to agree about. The idea that you actually have to have at least one example of an executed order, as opposed to having attended the camp and coming to the perception that by doing so you became part of the group. So I think there's some blatant disagreement right there. What about Judge Walton? Judge Walton, in the case called Garrity, states that detention authority encompasses only individuals who are members of the enemy armed forces as that term is intended under the laws of war. As that term is intended under the laws of war. Members of the enemy armed forces. The opinion does not explain what Judge Walton thinks the laws of war say about what it means to be member of the enemy armed forces when you transpose that from, say, an international armed conflict involving a regular armed force with its uniforms and its hierarchy, to transnational affiliation networks. So we don't really know whether this is the same in its actual cash out as the Judge Bates standard or wildly different. There's no telling. He does say this does require having a structured role in the hierarchy of the enemy force, receiving and executing orders from the enemy's combat apparatus. Now that's interesting language. Combat apparatus raises the possibility of an embrace here of the idea of a distinction between military wings and socio-political wings or other forms of non-combat wings of these organizations. And as I think many of you know, this is a familiar debate in how we think about terrorist organizations, especially ones like Hamas, Hezbollah, which are not an issue here, but who sort of symbolize or are paradigms of the multifaceted organization. So there's some possibility here that Judge Walton is embracing that view. Hard to say. There's no discussion in any event of the IAC-NIAC distinction, bats for civilians, any of the other things that might complicate this analysis. Just a general reference to the laws of war informing this. And this, I would submit, is characteristic of things that the government does in its brief, that the detainees do in their briefs, and that the judges do in their opinions. They all have a habit of sort of grandly referencing LOAC or laws of war, what have you, whatever acronym we use in this setting, and very rarely reveal the great ambiguity and debate that lurks beneath the surface there. There's just this assumption of clarity that's utterly not there, and I don't know if I can't explain why exactly that is. That's how it's going down. Now, our Judge Bates and Judge Walton, who've had the most, their opinions have garnered the most Me Too's from other judges. Are they really that different? Are they the same? Interestingly, you don't have to take my word for it. The judges themselves disagree about this question, right? So there's meta-disagreement about whether they're the same. Judge Hogan has an opinion where he notes the two opinions and says, you know, these are different verbiage, but it's functionally the same. You get to the same place, so there's no need to choose which one you like more. But Judge Kessler, in a contemporaneous opinion, noted the two different positions, said they are different, and I prefer Judge Walton's formulation and Garrity as opposed to Bates' formulation. So the judges don't agree about whether they're all agreeing or not. This is potentially problematic. And then there's Judge Naval in Bassard, which is a case, it's a unique case in certain respects. It's not enough to show that a person was detainable on the front end. The government must show, in order to keep detaining him, that the particular detainee personally is likely to be a threat going forward if released. And on that basis, she ordered the release of a man who, no disputed, had trained at a camp, an Al-Qaeda-sponsored camp, had been at Tora Bora, but in detention at Guantánamo, he had become notoriously cooperative. There had been a Washington Post story disclosing his identity. Where to go, Post? There was a widely agreed perception that this is a guy who's never not going back to Al-Qaeda. Al-Qaeda, if anything, we would probably want to kill this guy if he were to ever walk free again. And Judge Naval said, look, that person's not a future threat by definition. Therefore, you have no authority to detain him at all because he's cooperated with you so much. That's an interesting dynamic for you if you're constructing your interrogation plan. Don't get this guy too cooperative because he's going to have to be let go soon thereafter. Now, to be fair, not everyone perceives this landscape I've just described to you as uneven. There are people who would say that is a very slanted take. Chesney is sort of selling you this idea that it's a big mess. It's not that big a mess. The primary example of this viewpoint is a report that Human Rights First and the Constitution Project recently issued on behalf of a group of retired federal judges, and the title of the report says it all. Habeas works. It's the title of the report. The report concludes that lower courts are, quote, steadily progressing towards a workable detention standard, that it's not right to say, as I should mention that a lot of this is said in much more detail in a report that Ben Wittes, Rabia Ben Halim, and myself wrote for Brookings back in January. If you're interested in seeing the full massive report, you should go to the Brookings website and search my name, you'll find it. And this Habeas Works report says, it's not true that the judges are having to draft a substantive standard. Instead, the judges are merely interpreting and applying, close quote, the standard established in the AUMF. Now, the AUMF only says all necessary and appropriate force as to the groups the president determines perpetrated 9/11 attacks and those who harbor them. So I'm not so sure about that. The report describes this process that I've described to you in these slides as a gradual exploration and shaping of the detention standard in traditional common law fashion. I think that's right. That is an accurate descriptive account. The question is normatively whether this is the right context for a common law granular development case by case of what the detention standard is. In any event, the district courts, of course, don't have the last word. This is something that the Habeas Works report emphasizes, that insofar as there's variation, the D.C. Circuit and the Supreme Court above it smooths it out over time. So let's look at what they've been saying. This is interesting, too. The first case, the key case, is al-Bahani. The opinion there, the majority of the panel is Judges Kavanaugh and Brown. They said many interesting, some provocative things. First, LOAC is irrelevant. It is solely a question of domestic law. That is the current D.C. Circuit last word on the subject. LOAC is explicitly said to be irrelevant. Don't even say human rights law. Right? Purely a domestic question, and you look to things like the AUMF, the Military Commissions Act of 2006, and the Military Commissions Act 2009, and you work with it from there. Very interesting. As far as what makes you detainable, certainly membership tracks or support tracks, either or both, are fine. You don't have to abandon independent support. That can be a ground for detention. And in terms of proving membership, in dicta, it wasn't actually an issue in the fact patterns. It's dicta, but the court said in a very, very conspicuous footnote, training camp attendance, that's good enough, full stop. Or it could be good enough, full stop. And indeed, proof that someone stayed at a guest house without more could be adequate proof. Now we're getting down into the nuts and bolts of what we're really talking about here. These are dramatic positions to stake out. So, what else did they say worth mentioning? There's nothing in that opinion I want to dwell on. Let me jump ahead to Awad, or recent panel opinion. Very different panel. Chief Judge Sentel and Judge Tatel and Garland. So this is not where Brown and Kavanaugh are thought of as very conservative justices. Here you have two of the less conservative members of the court on the panel with Judge Sentel, and they treated al-Bahani as circuit precedent and said the following. In addition, oh wait, my slide's correct. I meant to mention. You may hear this business in al-Bahani and think, well, okay, that's just the panel's ruling. What's going to happen next? It is up for en banc review by the circuit. That'll be where it comes to an end. It's not clear that a Justice Kagan, assuming we're going to have one, would have to recuse herself. I don't really know to what extent she may. She wasn't on the briefs here. I don't know to what extent she was involved in the case. But my sense just from reading the papers is that the Solicitor General's office has been pretty heavily involved in helping craft litigation strategy in the Habeas context. I'd be a little surprised if she could participate in those cases if they go up all the way. So that means you'll have 8 justices, 4-4 probably. I think we know our court. That's a guess. It's 4-4, and when it's 4-4 and the court doesn't have a majority to overturn something the circuit has done, what's the result? Affirmance. Affirmance without further comment. So that may be locked in. Watch that en banc review. Now, there's reason in Awad to think that there's not going to be en banc review of al-Bahani, because the 2 justices who you would think would be very much, or 2 judges in the D.C. Circuit who might be most interested taking issue with some of the very broad bold statements in Al-Mahani, in Awad seem to have or express no particular problems with it. You never know, but they emphasize in a quiet rebuke, I think, to Judge Naval, no need to show future dangerousness, and calling into question both the Garrity and the Bates positions on having to have an evidence of a position in the command hierarchy. They reject that as well. So where does that leave us? It brings us back to the same standard we've had, with the addition, I should have included the word substantial here. It brings us right back to the position that's effectively been the same for the past two administrations. Now, what law is informing all this? How should we feel about all this? It's tempting to say that all this is just a legacy issue. I mean, yeah, it's interesting because this is front page newspaper stuff. The media loves Guantánamo. But at the end of the day, this is small fry compared to Afghanistan and Iraq and other things happening. That this is also a legacy issue you don't have to worry about. It's something that DOJ Civil Division's got to grapple with as these legacy cases filter through the system. But beyond that, don't worry about it. I don't think that it's that easy to dismiss it. We could ask a series of questions. Is it only relevant in the habeas setting? Well, if you are staff judge advocate advising a commander in Afghanistan and you're dealing with detention operations there, is it relevant to you what the federal courts back home are saying about the scope of the AUMF? Granted, they're only doing it because there's Guantánamo habeas litigation in front of them, but they're not offering opinions on the scope of Guantánamo habeas detention power. They're offering opinions about the scope of the AUMF. Is it relevant to your commander what the scope of the AUMF is, as construed by the federal judges back home? I don't think that's kind of relevant. So there is that. It's certainly going to be even more relevant, of course, if habeas actually formally extends to Afghanistan. As I think many of you know, this has been being litigated, or has been litigated. The case is known as Al-Makala v. Gates. Presented the question, in fact, does Boumediene apply not just to Guantánamo, but also first at the VTIF, at the Bagram Internment Facility, or now at the DFIP, the detention facility in Parwan? Did I get that right? DFIP. Judge Bates, again, had this case at the district court level, and he issued a split decision in which the answer was no for Afghans or people captured in Afghanistan, but yes for non-Afghans brought in from outside the theater. And so habeas got its first toehold there, but everyone knew this was going to go up on appeal. And last month, or I guess a month and a half or so now, the circuit chimed in and reversed Judge Bates, saying no one gets habeas. This is a theater of active hostilities. It's different than Guantánamo on that dimension, and so Boumediene simply does not extend. Kagan was on the briefs on that one, so there's not going to be Supreme Court review, I would tell you. On Al-Makala, the only question is en banc, and frankly, I don't know where the status of this one is in terms of a possible en banc. But much more importantly, although this has been reported as being the end of the possibility of habeas going to Afghanistan, it's not so. The panel opinion was very careful to say that the particular fact pattern before it, because the out-of-theater detainees in that instance have been transferred a pretty good time back to Afghanistan, pre-Boumediene. The panel said this wasn't a circumstance where the evidence suggested that people were being brought from out of the country into Afghanistan just to make sure that there would be habeas review. And they explicitly said, if you got a different fact pattern where it looked like people were being brought there to avoid habeas review, all bets are off. So for those of you for whom this is directly relevant, do not assume that the Al-Makala Circuit Court ruling is the end of having to worry about possible direct implications for habeas. So the door remains open there. A last thing to think about also for commanders, obviously there's at least some potential hangover for detention operations in Afghanistan. About targeting, let's not forget that as long as, even if the courts never go back to that suggestion that DPH should somehow define detainability, which I don't think they're going to, nonetheless, doesn't it still matter to you if you're trying to figure out whether that drone can strike that particular target package involving someone who's an interesting case under the heading of associated forces or support? Isn't all of this jurisprudence that the habeas litigation is turning up, isn't this highly relevant for you to consider? I'll leave you with that thought because I think that really, these points really kind of capture the idea. The real takeaway here is that we have an asymmetric and counterinsurgency context that's generating all kinds of hard questions about what the law of armed conflict may have to say or may not have to say. And what's really happening is not much engagement with low-act materials, but instead much more of a free-form, ad hoc jurisprudential process in which courts are evolving rules. They're fumbling and working their way in a granular fashion towards resolving these matters. And it matters what they're doing. This is the form in which they're doing it. Perhaps this is how it's going to be going forward. This is where these rules are going to be made. It would be a terrible mistake for you to think that this is something that's really just a civil litigation matter that's a legacy issue for Guantánamo. It's much more than that. So I'd love to take questions or criticisms or suggestions.
Yeah, we're going to have to go back up to stay on schedule.
Okay.
So I apologize.
Even better. So I'll assume you all agree with me. Thank you very much.